Hello, everyone. My name is Kelly Nash, and welcome to today's webcast, Tips, Best Practices, and Hot-Button Issues of Commercial Mediation and Arbitration. This event is brought to you by Law.com and sponsored by NAM. Before we begin, let's go over some basic housekeeping items about the webcast console. First, this event is completely interactive and incorporates many of today's social media tools. You can tweet or directly post information to your Facebook and LinkedIn pages right from the console without having to open a new browser. Simply scroll along the bottom of the screen and click on the social networking widget of your choice. In fact, we encourage you to do so. If you have a question for one of our speakers, please enter it in the Q&A widget on your console. We will get to your question either during the event or during the live Q&A at the end, depending on how much time we have. We will answer as many questions as possible, so we invite you to ask away. If we don't get to your question, you may receive an email response after the event. In addition, there are some other customizable functions to be aware of. Every window you currently see, from the slide window to the Q&A panel, can either be enlarged or collapsed. So please feel free to change the look and feel of your console as it suits you. Also, this event is CLE eligible. CLE has been approved in the states of California, Illinois, New Jersey, and New York only. Participants who wish to receive credits for other states must check directly with their CLE board. Within an hour after the presentation, all attendees will receive further instruction via email on how to receive your CLE. During this presentation, the CLE code will be announced. New Jersey and New York attorneys should also be sure to retain the code for their records, since they will need to re-enter it in order to download the CLE certificate. The CLE certificate will be available for download 1 week after the event on July 2nd. CLE credit is available for attorneys in the approved jurisdictions, provided that you view this event live for 50 minutes or more. And now for today's topic and the reason you are all here. Alternative dispute resolution methods, such as arbitration and mediation, are often explored to reduce the uncertainty and expenses of litigation and to reduce and resolve business disputes. Here to address the latest developments and hot-button issues in commercial mediation and arbitration are Rhonda Epstein and Jim Wrynn. Rhonda is an employment law specialist at NAM and is a seasoned litigator with more than 35 years of wide-ranging experience in civil litigation. Jim is a former superintendent of the New York State Insurance Department and hearing officer at NAM. Jim brings more than 30 years of professional experience as an attorney, regulator, executive, and strategic advisor in the domestic and global insurance and regulatory sectors. So without further ado, I'd like to welcome our speakers here today and pass it over to Rhonda, who will kick off our discussion. Rhonda?
Good afternoon, everyone. We have a pretty ambitious agenda. We will cover every topic in more details than others. Rather than read them all to you, I think everyone has mastered that skill. So we're going to just jump right in and focus on employment disputes and the recent changes in the law. It has been general legal principle that before an employee could file a Title VII lawsuit in federal court, they first had to file a charge with the EEOC or local administrative agency. Well, a recent case, and I mean recent, June 3rd of this year, the Supreme Court limited a procedural defense that employers had prior to this time. It had been that, again, that employees had to file with the EEOC. In this particular case, which is Fort Bend County versus Davis, Ms. Davis filed an EEOC charge alleging sexual harassment and retaliation against her employer. And while that charge was pending, she was asked to work on a Sunday. She refused, stating that was her day to go to church, and she was ultimately fired. She then filed suit directly in federal court claiming sexual harassment, retaliation, and religious discrimination. After years of litigation, when only the religious discrimination cause of action remained, the county moved to dismiss on jurisdictional grounds, meaning that she hadn't filed that religious discrimination charge at the EEOC. And the Supreme Court held that the delay in moving on that ground meant that the employer forfeited the defense. So Justice Ginsburg rejected the argument that filing with the EEOC is jurisdictional, and instead she said it was a prerequisite processing rule. Play on words, but again, the defendant lost that very valuable defense. So the takeaway is If you represent an employee, then you should make sure that when you file at the EEOC, that you include every cause of action, and if the situation changes while the charge is pending, that you amend the charge. Employers, on the other hand, if they receive a lawsuit after a charge, they should be sure to make sure that every cause of action is also included in the original charge. And if it's not, they should assert the defense at that time and not wait. Now, on a more local level, New York recently extended liability for harassment to non-employees, meaning that an employer can be liable for non-employees that are providing services in their New York State workplace. Not off-site, though, only if it's in New York State on their premises. So that would include contractors and subcontractors, vendors, consultants, or any other individuals. Now, that would happen if the employer knew or should have known of the harassment, and if the employer failed to take immediate and appropriate corrective action. So essentially, it's treating people that are at your work site in the same manner as if you treat your employees with regard to harassment. Pretty much common sense. The next change in New York, which is a result of the Me Too movement, is that effective last summer, in a settlement agreement, you can no longer make it confidential if the foundation of the claim involves sexual harassment, meaning that you cannot include a confidentiality clause in your settlement agreement unless it's the complainant who wants that provision. Now, to be honest, generally when you settle an action, there's always a confidentiality agreement, and it's a negotiated term, and sometimes it requires that the defendant or the employer pay more money. Now it specifically has to be said that it is the provision that the employee wants. Additionally, an employee has to be given 21 days to consider whether or not to accept or refuse the non-disclosure provision, and this 21 days is not waivable. So it's similar to the ADA, but under the ADA you can waive the 21 days. Here you cannot, which means that severance payments are going to be delayed by 21 days. You have to have a very carefully worded settlement agreement. There are some questions that have not been answered yet. Would it apply to every case pending in New York, even if the employee worked elsewhere? So if the company was based in New York, but the employee worked in New Jersey, does this provision apply? If the employer is a multi-state employer, can they write the agreement such that it's governed by the laws of, Delaware or wherever the corporate headquarters is? Again, I don't know. So again, employers should be careful. I should employees, counsel, to make sure that the settlement agreement is specific if there's a confidentiality agreement and that it specifically says that it's at the request of the employee. Another result of the Me Too movement is that effective October 9, 2018, sexual harassment training for all employees in New York State is mandated. New York State Department of Labor and the Division of Human Rights has a model policy and program. You can actually see it if you go to the New York State Division of Human Rights website. The training is supposed to inform employees of their rights of redress, explain what sexual harassment is, and explain retaliation. And lastly, it's supposed to include a model complaint. So for anybody who has not had their clients put this training into effect, you have some time, but first training must be completed by October 9th of this year. Okay, back out nationwide, there are 3 Supreme Court cases that the courts agreed to hear this year, which may determine whether sexual orientation and gender identity will be covered under Title VII. Right now, there's a split in the circuits. So the Second Circuit had a case that concluded that if sexual orientation is bias motivated, at least in part by sex, then it's a subset of sex discrimination. In the 11th Circuit, which is the state of Georgia, the court rejected a very similar argument. And lastly, there is a case coming out of the 6th Circuit, which is actually the first appellate court that extended Title VII coverage to transgender and transitioning employees. So again, the lower courts hadn't reached a decision on that prior to this. Now, just some really local new laws that are not in the slides is that New York City, effective May 10th of this year, and it takes effect May 10th of next year, and it's the first of its kind in the country, makes it unlawful discriminatory practice under New York City human rights law to require a prospective employee to submit to testing for the presence of any THC or marijuana in that prospective employing system as a condition of employment. Now, there are certain exceptions if the position requires supervision of children and medical patients, or the positions require a commercial driver's license, or positions that require federal drug testing, then this law won't apply. So an employer can still prohibit marijuana use at work and can still prohibit employees from working while impaired, but cannot test for it. Another law that's very new that went into effect this March is that in New York City, employers need to provide a lactation room and a refrigerator for breast milk in a reasonable proximity to an employee's work area. And then another law is that, effective in February this year, makes it unlawful to refuse or hire or discriminate on the basis of an employee's gender identity or expression, or in the terms and conditions of employment or compensation. And lastly, there's a paid voting leave effective this April that a registered voter may take up to 3 hours without loss of pay to vote. So with that, I'm going to now hand this off to Jim to talk about insurance disputes.
Good afternoon, everyone. I am going to cover a number of the topics on today's agenda, beginning with, as Rhonda just mentioned, insurance disputes, to explain why they're somewhat unique. In that regard, on my first slide, I give you a brief history of insurance, so some idea as to how our national system of state-based regulation came about and its impact on the applicability of the Federal Arbitration Act, which we'll discuss in a moment. And I'm going to start back in 1869 with the case of Paul versus Virginia over on the left side of the slide. Back at that time, the insurance business was exclusively regulated by the states. A variety of separate regulations developed throughout the states. However, the insurance companies, they wanted uniformity. And in an effort to promote federal regulation, a number of New York insurance companies came together to challenge a statute passed by the legislature of the Commonwealth of Virginia in February of 1866, which provided that insurance companies not incorporated under the laws of the state should not carry on its business within the state without previously obtaining a license for that purpose and depositing with the state treasurer a bond. In May of that year, Samuel Paul, a resident of Virginia, was appointed agent by the New York insurance companies. He applied for a license to act as an agent within the state and offered to comply with all the requirements except the provision requiring the depositing of a bond with the state treasurer. Based on his failure to fully comply, he was denied a license. Notwithstanding that fact, that he undertook to act as an agent in the state for the New York insurance companies. He was caught and subsequently indicted, convicted, and sentenced to pay a fine of $50. The judgment was affirmed by the Supreme Court of Appeals of Virginia and ultimately brought before the United States Supreme Court. Samuel Paul claimed that the statute that he was being prosecuted under was invalid in that it violated both the Commerce Clause, which gives Congress the power to regulate commerce with foreign nations and among the several states, and the Privileges and Immunities Clause, which provides that citizens of each state shall be entitled to all the privileges and immunities of the citizens in the several states. With respect to each of these arguments, the Supreme Court held, number one, corporations were not citizens within the meaning of the Privileges and Immunities Clause, so that clause did not invalidate the state statute. And just as an aside, although today a corporation is a citizen for service of process and under the Equal Protection Clause, it's still not a citizen within the meaning of the Privileges and Immunities Clause. But more importantly, for purpose of our discussion, the second holding was that the issuing of a policy of insurance is not a transaction of commerce within the meaning of the Commerce Clause, So that clause did not invalidate the state statute. They felt that the issuance of a policy of insurance was just a simple contract of indemnity against loss. The second case, which is the second column to the left, Hooper versus California, basically affirmed Paul versus Virginia. That case involved a section of the penal law of California, which made it a misdemeanor for a person in the state to procure insurance for a resident in the state from an insurance company not incorporated under its laws and which had not filed the bond required by the laws of that state. The agent in that case, Hooper, procured a marine insurance policy for an ocean steamer in California from an insurance company incorporated in Massachusetts, which had not filed the bond required by the laws of California. The agent was charged before the police court and convicted of a misdemeanor. That was appealed and ultimately went up to the Supreme Court, which affirmed and again held that the issuance of a policy of insurance is not a transaction of commerce within the meaning of the Commerce Clause. And again, as an aside, Hooper versus California got a little publicity in 2012 when Chief Justice Roberts cited it in upholding the individual mandate provision in the Affordable Care Act in the case of National Federation of Independent Businesses versus Sebelius. The third case is New York Life Insurance Company versus Deer County Lodge. And just very briefly, that involved a tax levied on every insurance company transacting business in the state of Montana. New York Life Insurance Company alleged that tax was illegal, unlawful, and void under the Commerce Clause. The action was dismissed and then sustained by the Supreme Court of the state of Montana, again finding that the issuance of a policy of insurance was not a transaction of commerce under the Commerce Clause. Then in 1944 came along the case of U.S. versus Southeastern Underwriters. And Southeastern Underwriters Association was 200 private stock fire companies, 27 individuals, and it controlled 90% of the business in 6 southeastern states. The association was indicted in the district court for alleged violation of the Sherman Antitrust Act. It was alleged that they were restraining interstate trade and commerce by fixing and maintaining arbitrary and non-competitive premium rates on fire and specified allied lines of insurance. U.S. Justice Black in the U.S. Supreme Court wrote the Supreme Court opinion, and he did an analysis on whether the issuance of a policy of insurance was a transaction of commerce and found that the modern insurance business held a commanding position in trade and commerce in the U.S., and it was one of the largest and most important branches of commerce. And he cited the fact that total assets at that time exceeded $37 billion, which was the approximate value of all the farmlands and buildings in the U.S. The premiums exceeded $6 billion, which was more than the average annual revenue receipts in the U.S. government for the last decade. And the labor force was approximately 524,000, which was almost as many as people working in coal mines and the automobile industry. And he said, no modern commercial enterprise has directly affected so many people in the home, family, occupation, as business as the insurance industry, and found that the issuance of a policy of insurance did, in fact, constitute a transaction of business within the Commerce Clause. It also found, that led in turn, and that was in June of 1944, that led in turn to Congress passing legislation 9 months later that was called the McCarran-Ferguson Act, which was a bill actually proposed by the NAIC, which is the National Association of Insurance Commissioners, which provided that acts of Congress that do not expressly purport to regulate the business of insurance will not preempt state law or regulations. It also provided that federal antitrust laws will not apply to the business of insurance as long as the state regulate in that area, except in the cases of boycott, intimidation, or coercion. But the big thing was it really relegated or it confirmed the national system of state-based regulation unless the the federal statute expressly referred to the business of insurance. And as you'll see, there have been many times where the federal government has passed legislation that was directly applicable to the business of insurance. The first two, the FDIC and the Federal Crop Insurance Program, predated the McCarran-Ferguson Act, but the remainder are acts that specifically related to the business of insurance and preempted state regulation to that extent. Now, the Federal Arbitration Act was actually enacted 20 years before McCarran-Ferguson, and this act significantly limited and still limits a state's ability to bar or restrict arbitration clauses. It provides, as I provide there, that a written provision in a contract evidencing the transaction involving commerce to settle by arbitration a controversy thereafter arising out of such contract or transaction shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. Now, the courts have interpreted this as preempting most state anti-arbitration laws, but the key word there is most. This is not necessarily true with respect to provisions banning or restricting the use of arbitration clauses in insurance contracts. The FAA and the, let me explain further the interplay between the FAA and the McCarran-Ferguson Act. As most people listening in know, there are a variety of state laws regulating arbitrations in insurance contracts. A number of states have no statute or regulation in force prohibiting or restricting the use of arbitration in insurance contracts. A significant number have statutes that appear to prohibit the use of arbitration clauses by insurers. Several have restricted or limited the application of these clauses in insurance contracts, and a few states have exclusions for particular types of insurance contracts. Since the FAA is cital on its application to insurance contract, the position of the states is strong under McCarran-Ferguson, where they seek to limit, restrict, or prohibit the use of arbitration clauses in insurance contracts. A very good in challenging the state antitrust, the state anti-arbitration laws, insurers tend to rely, as you would expect, on federal preemption of state action by the Federal Arbitration Act. Policyholders or the states looking to enforce their own laws rely on McCarran-Ferguson state regulatory authority under what has become known to be reverse preemption. And there are 3 requirements for reverse preemption, and if those requirements are met, basically state law wins. And the 3 are listed below, and one is federal law does not specifically relate to the business of insurance, and you could substitute federal law for the FAA, and the FAA really does not relate to the business of insurance, so that would be satisfied in most cases. The second is that the state anti-arbitration law must have been enacted for the purpose of regulating the business of insurance. So that would be a very important condition. If it was not acted for that purpose, chances are reverse preemption wouldn't apply. And the last is that the federal law, again, you can substitute the Federal Arbitration Act in question, would invalidate, impair, or supersede the applicable state law. As you can imagine, cases challenging arbitration clauses are policy and fact specific. So if the state statute is narrowly constructed to apply to the business of insurance, it most likely will not be preempted by the FAA. A very good example of the interplay between the FAA and the McCarran-Ferguson Act and the reverse preemption analysis by the courts is provided in the 2016 New York Appeals case of Monarch Consulting versus National Union. I don't have this in the outline, but I think it would be it's a very instructive case to hear, and I'll explain it briefly. In Monarch, the Court of Appeals unanimously reversed a decision of the Appellate Division First Department, which had consolidated 3 actions and decided to enforce arbitration provisions contained in a series of side agreements known as payment agreements that were not filed along with the related workers' compensation agreements as required under the California Insurance Code. So the workers' comp policies were filed, but these side agreements were not. The issue before the Court of Appeals was whether the McCarran-Ferguson Act precludes the application of the FAA in relation to the failure of the company to comply with the filing requirements contained in the California Insurance Code. To resolve the parties' contentions, the court stated that they must determine whether the McCarran-Ferguson Act preempted the FAA. They then conducted their analysis of the three requirements for reverse preemption and found, with respect to the first, that it was satisfied because the FAA does not specifically relate to insurance. The second requirement was also satisfied since the applicable state statute, the filing requirement contained in the California Insurance Code, clearly was enacted to regulate the business of insurance. However, with respect to the third requirement, the court that held that it was not satisfied because it did not at all relevant times prohibit, limit, or regulate the use or form of arbitration clauses in an insurance contract. It also held that the California law did not and still does not prohibit arbitration in the insurance context. As a result of this case, or as a result of the above, the court held that because application of the FAA does not invalidate, impair, or supersede the California state statute, the McCarran-Ferguson Act is not implicated, and the FAA applies to the parties' payment agreements in this case. They also noted that the California Insurance Department can still do an enforcement proceeding, but as far as the enforcement of this provision under the law, it was enforceable. There was another issue decided by the court. They further held that because the parties had clearly and unmistakably delegated the question of arbitrability and enforceability of the arbitration clauses to the arbitrators, the FAA mandates that the arbitration provisions be enforced as written. And that leads us right to the next slide as to the questions of arbitrability and who decides, the court or the arbitrator. There are a number of grounds a party could argue the dispute is not arbitrable. For example, the arbitration clause does not cover the dispute in question, the underlying contract is invalid due to illegality or unconscionability, or a condition precedent has not been met. The question of arbitrability is not expressly addressed in the FAA, but in a series of decisions by the U.S. Supreme Court, which have given rise to the separability and the delegation doctrines. The separability doctrine was first enunciated in the case of Prima Paint versus Flood and Conklin Manufacturing in 1967. It provides that when a party enters into a contract containing an arbitration clause, they're actually entering two separate agreements. One, the underlying contract, and two, the arbitration clause. The Supreme Court in Prima Paint held that arbitrators decide challenges to the validity of the contract, whereas the court decides the validity of the arbitration clause. 35 years later, in Howsam versus Dean Witter Reynolds, the Supreme Court, using the term gateway, and distinguished gateway or substantive matters that raise questions of arbitrability as being for the court, and procedural questions that grow out of the dispute and bear on the final disposition, such as the defense of waiver, delay, or like defense to arbitrability, are for the arbitrator. The U.S. Supreme Court recognized an exception to the separability doctrine where the parties expressed a clear and unmistakable intent to arbitrate questions of arbitrability. If they do express a clear and unmistakable intent, they can delegate this decision to the arbitrator. As I mentioned before in Monarch Consulting, that was one of the things that court found as well. However, several circuit courts specifically, recognized an exception to the exception and held that even where the parties expressed a clear and unmistakable intent to delegate this decision to the arbitrator, the court could still decide the issue itself if they found the dispute was wholly groundless. And the question for the Supreme Court, which had not yet decided this issue, was whether the wholly groundless exception was consistent with the FAA and the court's precedent. And as you'll see on the next page, the question went unanswered until January 8th of this year, when the Supreme Court decided in an 8-0 decision written by Judge Kavanaugh. It was actually his first written decision in Shine versus Osher and White, that it was not, and indicated that the wholly groundless exception would no longer be recognized. Now, very briefly in Shine, Archer and White sued Henry Schein, Inc., alleging violations of federal and state antitrust law under a distribution agreement for dental equipment, and sought both money damages and injunctive relief. The subject contract provided that any dispute arising under the agreement, except for, among other things, injunctive relief, shall be resolved by binding arbitration in accordance with the arbitration rules of the Arbitration Association of America. And those rules did provide that arbitrators have the power to resolve arbitrability questions. In invoking the FAA, Schein asked the district court to refer the matter to arbitration. Archer opposed on the grounds that it was wholly groundless, at least with respect to the fact that the complaint sought injunctive relief. The district court agreed with Archer and denied Schein's motion, and the Fifth Circuit affirmed. The U.S. Supreme Court then vacated the decision of the Fifth Circuit Court of Appeals on the ground that the wholly groundless exception to arbitrability is inconsistent with the FAA and the Supreme Court precedents, but remanded the matter to Court of Appeals to determine if the parties clearly and unmistakably delegated arbitrability to an arbitrator. So the court expressed no view on whether the incorporation of the AAA rules, which provided that the arbitrator has the power to resolve arbitrability questions, is clear and unmistakable evidence of the party's intent to delegate arbitrability to an arbitrator. So they actually remanded that question back down to be decided by the lower court. With respect to the clear and unmistakable evidence issue, an amicus curiae brief was submitted by Columbia Law Professor George A. Berman. It was dated September 25th, 2018, which argued that the incorporation of arbitration rules containing competence to competence language does not constitute clear and unmistakable evidence of intent to arbitrate arbitrability required by the first options case, which we noted before. Competence to competence is a doctrine recognized in many countries, which refers to an arbitral tribunal competence to determine over its own jurisdiction. It does apply in many other countries, but not here. And we go to the next, the takeaways. Again, it's another series of Supreme Court cases confirming the enforceability of arbitration agreements. It highlights the fact that parties must clearly and unmistakably provide what types of disputes are subject to arbitrations and those that are not, as well as their intent to delegate threshold issues such as arbitrability to an arbitrator. However, when they do clearly and unmistakably express that intent, the parties can be more confident that these issues will be decided by arbitration now that the wholly groundless exception is eliminated. But again, that question of what constitutes clear. Yes, go on. Sorry.
Jim, I'm sorry to interject. If we could just take a moment to read out the CLE code, I'm sure everyone in the audience is eagerly awaiting that.
Mm-hmm. Okay.
Great. So thank you. The CLE code today is Legal 25. That's LEGAL 25. Again, the code is Legal 25. Thanks, Jim. I'll hand it back over to you.
Oh, great. Okay, just very briefly, two other cases recently decided. A week after Shine was New Prime versus Oliveri, New Prime was an interstate trucking company that hired Dominic Oliveri to work as a driver pursuant to an independent contractor operating agreement, which contained both an arbitration clause and a delegation clause, giving the arbitrator the authority to decide the threshold question of arbitrability. Oliveri filed the lawsuit alleging failure to pay minimum wage, among other things, and New Prime filed a motion to compel arbitration. Oliveri countered, arguing that Section 1 of the FAA excludes contracts of employment of any class of worker engaged in interstate commerce. And the three court decisions are very interesting. The first one was Massachusetts District Court, which held that questions of arbitrability are for the court, but found that independent contractors were not employees under the exclusion. The First Circuit agreed that the applicability of the exclusion was for the court, but found that independent contractors were employees within the meaning of the FAA at the time it was enacted, going back now to 1920. And the United States Supreme Court held that it was the purview of the court to determine under Section 1 of the FAA whether an exclusion applied before ordering arbitration. So the court must decide, is it under Section 2, a transaction involving commerce, and number 1, do any exclusions apply? And lastly, with respect to Supreme Court cases, this involved an action by an employee who was one of 1,300 employees that had their information hacked, who brought an action against the employer. The employer immediately made a motion for arbitration, but the court granted the motion not for individual arbitration, but for arbitration on a class-wide basis. The employer, Lamb Plus, then appealed, and the circuit court affirmed, but the Supreme Court ultimately reversed and held that under the FAA, consent is essential, and courts may not infer consent to participate in class arbitration absent an affirmative contractual basis for concluding that the party had agreed to do so. So the court continues to strictly interpret clear intent of the parties under arbitration agreements, resulting in this instance in a big victory for the employers looking to arbitrate workplace claims on an individual basis. I have two more quick sections. The first has to do with legislation that was proposed in New York, and although the first two did pass the Assembly, none passed both houses, so they are still proposals at this point. The New York City Bar Association felt that these bills posed a risk, perhaps inadvertently, to business-to-business arbitrations and jobs in New York, and submitted a paper opposing them. And the first one basically provides that arbitration awards in consumer and employment disputes shall include all issues in dispute and findings of fact and conclusions of law. And as most of us know, writing a decision including all those things can take longer many times, or add significant cost and expense to the process. The second authorizes the vacating of an arbitration award on the basis of arbitrated disregard of the law. And again, that adds another section to 7511 on provisions where the decision can be overturned. The third required employment and consumer dispute arbitration to be submitted to a neutral third-party arbitrator. And we know that in some industries, such as reinsurance, they actually have non-neutral arbitrators that ultimately choose an umpire, which is a neutral. And the last one has to do with required disclosure of potential conflicts. But again, 7511 does already have some provisions, with respect to that. But they felt that that this could have a negative impact on New York as one of the leading jurisdictions in the world for arbitrations and mediations, particularly for the business-to-business, commercial, financial, intellectual property, maritime and insurance disputes. And they cited that New York passed the first arbitration law in the country in 1920. It has the infrastructure. It has a number of Arbitration and Mediation, organization, NAM, AAA, JAMS, ARIAS. And even more importantly, the New York courts have shown a high degree of deference to arbitration awards. As recently as last year, in the case of Desang versus NutraSuite, which reaffirmed New York's pro-arbitration attitude, the First Department reversed the trial court's vacature of an arbitration award and reaffirmed that judicial review of arbitration awards is extremely limited. They did a very comprehensive report that was submitted to the legislature, which may have in fact resulted in the holding off or the holding back on the passage of these bills in the various houses. And rather than go through the specific issues they had with each, I'll simply refer you to the report, which does provide a very comprehensive analysis as to the impact and the fact that what they were proposing in these bills was really not needed under the current legislative environment. The last thing is presumptive ADR, and this is a statewide court effort. New York State Chief Judge Janet D. Fiore, in her State of the Judiciary address in November, highlighted the need for formal expansion of ADR in non-criminal matters. In May, she and the Chief Administrative Judge, Lawrence Marks, announced a statewide initiative as part of her Excellence Initiative, in which parties in civil cases will be referred to mediation or some other form of ADR as the first step in the case proceeding to court. It's called presumptive ADR and will apply to a broad range of cases from personal injury to matrimonial, as well as state matters and commercial disputes. To accomplish this, Deputy Chief Administrative Judges George Silver in the city and Michael Kama in the state, along with their with their staffs, who work closely with the various administrative judges in each county, the trial court judges, the bar associations, and other stakeholders, to expand the number and scope of court-sponsored ADR programs in their respective jurisdictions. The court system will issue uniform rules to authorize, endorse, and provide a framework for the courts to introduce and expand these programs using volunteer mediators, neutrals on court rosters, judges, non-judicial staff, judicial hearing officers, and community dispute resolution centers. Implementation and rollout of this program is scheduled to begin in September. So with that, I will turn the microphone back over to Rhonda to continue on best practices.
Okay, thanks, Jim. The one thing I would say about the last slide on the presumptive ADR is that most of the federal courts across the country have some sort of ADR. In New York, it's mandatory in employment cases in the Southern District. It's available in all the other districts. It has had some impact, but not a major impact. And so it'll be interesting to see how it plays out here and whether it's followed across the country. But that being said, let's move forward and talk about best practices in reducing and resolving business disputes. The first thing is to decide whether or not we're looking for an exit strategy or reconciliation, because that will then determine, or might begin to determine, what manner in which we'll proceed. So if it's definitely an exit strategy, one might go immediately to litigation, because it's invariably you're throwing down the gauntlet. The next thing would be arbitration, which also is usually an exit strategy. Mediation can be an exit strategy, but could also send a signal that you are trying to resolve the situation and maybe somehow put the relationship back together again. And in mediation, which is an option that I like very much, it is something where it's only limited by the imagination of the party. So you really can formulate your own resolution and framework to a problem. And of course, it can always be a combination of all these various mechanisms, and it can start out as an arbitration. Well, let me just go to the next slide. Basically, the factors that you'll consider when choosing the correct dispute resolution will be the culture of the organization, the time and expense, because we all know litigation is very expensive, followed only by arbitration in terms of cost, both in time and money. But also, the relationship between the parties are often governed by a contract, and the contract may specifically state that it has to be arbitrated. That being said, even if a contract is specific, it's a negotiated term, so the parties can always get back in there and renegotiate the framework and say, we now want to go to mediation, or at least give mediation a shot. And I've had that situation where something was in arbitration. After some discovery had taken place, the party said, maybe we should go to mediation instead of continue with arbitration. So you're not really locked in. And again, even with litigation, you can start out in litigation, start with the discovery, conduct some depositions, and then say, let's go to mediation. So no matter what you choose, you're not locked in. There's always other forms available. There's also lawyers involved in all of these disputes, and we take very different roles and depending on the case. So you have the in-house counsel representing one of the parties, who I like to think of as the team leader putting everybody together. And just because they're not the litigator, they don't have to be sitting on the sidelines or on the back bench. They can still be leading and directing the quote-unquote hired gun or mouthpiece of the litigation counsel into what they would like to see, because they're ultimately the one deciding the goals of the parties. The litigation counsel, again, is often chosen by the in-house counsel so that they can work together, and generally they've worked together in the past. Sometimes you'll have insurance coverage for the dispute, and that can be where a third lawyer can get in the mix, because the insurance company may select counsel to defend their insured, which may have the original litigation counsel drop out, drop down, or somehow or another you can be involved with 3 lawyers in the case. Either way, it shouldn't matter, because everybody still has to play nicely in the sandbox with one another. Although there can be divergent interests with an insurance carrier, because the insurance carrier might want to settle quickly and not be concerned about the precedent that a case might be taking. In-house counsel really knows the facts better than anybody, at least at the inception of a claim, because they've lived with it. It's their company. They also know the documents best, the witnesses best, and they may have already had interactions with their adversary and their counsel, either by a claim letter or some other type of negotiation. So they are really a good resource, and the litigation counsel should not overlook or downplay the role of general counsel. So the general counsel is also there to communicate with the other people in the business or the corporation, and can, I guess I don't want to say translate legalese, but yes, they can translate the legalese. Throughout the litigation, it's generally the general counsel who is going to set the tone and determine how things are going to happen, at least from the company's point of view. Very often it's not just money. They're going to have to determine any of the non-monetary relief that's being sought and what they're willing to compromise on or not compromise on. Again, the money may be held by the purse strings, might be the corporate purse strings, or they might be the insurance company's purse strings. But either way, counsel needs to be on the same page before going forward and presenting their solution, or their offer, I should say, to the other side. They also set the tone if you're in a mediation or an arbitration or in court, because that counsel is, the corporate counsel is also the representative of the company, and their demeanor and the manner in which they present to the mediator or the arbitrator or the judge can influence the opinion and the outcome of the case. They're also there to refute any factual claims that the other side may be stating that might not be in the record, but they are in the room, so they can say, no, that didn't happen. So if the adversary says, well, 3 years ago you settled the claim, so on and so forth, that general counsel should know whether that's true or not and will be there to say yes, but, or no. And they can also explain any books and records and really be a witness because they would have the knowledge. They also have, again, the history of the claims and the relationships. And very often that person in the room, just by their very presence, can signal to the other side that the company is taking their claims seriously, that they respect them, and it can often help with a settlement, especially in an employment case, because very often if an employee is not feeling heard, having somebody as high up in the corporation as the general counsel being there, listening to them, and spending the time can facilitate the settlement and sometimes even lower the monetary value of a settlement. I don't know if anybody has any questions about that, but with that, I know there are some questions in the queue, and so I will end here and let those questions be asked.
Great. Thanks, Rhonda. Yes, we do have a few minutes left in this presentation, and we have had an interesting question come through from the audience. I think this question is probably best directed to Jim. The question is, why should arbitration clauses be enforceable, absent fraud, et cetera? Jim, you want to provide your thoughts around that, perhaps?
Yeah, the question is, why shouldn't they be enforceable absent fraud?
Why should arbitration clauses be enforceable?
Why should they be enforceable absent fraud? Well, yes. A lot of times there's other issues. The parties may not have intended it to apply to that specific dispute in question. In addition to fraud, there's illegality and unconscionability. There's certain condition precedents that have to be made. And there's statutes out there that could impact that, and I explained the interplay between the FAA and some of the state statutes and the applicability of the McCarran-Ferguson Act. So there are other reasons than fraud that could impact whether or not a clause should be enforceable.
All right, makes sense to me. Thank you. Another question that has come through is, what if an employee will not agree to confidentiality?
Well, I think I'll take that one. If you're in New York, you really don't have much recourse other than you can say you're not going to settle, and then if you drag the litigation out further, it might soften their resolve. There's always that old adage, everybody has their price, and so if it means a lot to the employer to have a confidentiality agreement, then they might have to pay more money for it. But there's really no way around the statute, unless you want to try to be the trailblazer and say, well, we're going to keep certain parts of it confidential, maybe such as the amount of money paid, but not the allegations. That hasn't been litigated yet, and I don't know if I'd want to be the party taking that position.
All right, great. Here's another question that has come through as well. Do you ever see conflict between an insurance carrier and the insured over settlement?
Not often, but it can happen where an insurance carrier is looking at the cost of the litigation that keeps mounting and would like to settle a case, and their insured doesn't want to settle it because they're concerned about the precedent. or it's not just money that the other side is looking for. They're looking for certain accommodations that they're not willing or capable of giving. And so there can really be a push and a pull, but generally it doesn't happen. It's rare,
Right.
but it can happen.
Yeah, and there are some policies that require the consent of the insured, such as professional malpractice policies, and there you'll see it a little bit more because their reputation's at stake. So if you sue a doctor and the doctor side did nothing wrong, and the evidence may differ, you can find the attorney, fighting uphill to get the doctor to agree to the settlement.
And then you end up with a trial and a verdict.
Right. Okay, great. Well, we do have a couple of minutes left, and there's time for one final question. That question is, will the new New York rules, will a choice of law section state venue in an arbitration agreement still be enforceable?
I don't know. I'll leave that one to you, Jim, as the insurance expert.
I don't know. There'd have to be a reason for it not to be enforceable. So if the arbitration clause is enforceable, the choice of venue, in my opinion, would be enforceable. Again, I'm painting with a broad brush, but as a general rule, I would say the enforceability of that provision, again, it has to be reasonable. And where you may have a pushback on it are in situations where there's not an even playing field, like consumers, if the personal lines policy were to impact the consumer, courts may feel it's not equitable. If they say any dispute has to be resolved in New York and they're living in Des Moines, Iowa, a court may push back, on those provisions.
All right, great. Well, we are just about reaching the top of the hour. If anyone does have additional questions they would like to ask Rhonda or Jim, please feel free to submit them through the Q&A widget, and we will potentially answer them after this event. So thank you again, Rhonda and Jim, for all of your valuable insights today, as well as Law.com for their support. Thanks, of course, to everyone in the audience for joining us. We hope this discussion was useful to you. And also, just as a reminder, all participants will receive an email shortly after this event with detailed instructions on how to receive your CLE when it becomes available on July 2nd. You will then receive an email 1 week from today with instructions on downloading your state-specific CLE certificate. And remember, this webcast will be archived so you can reference it later. So with that, thank you all again, and have a great afternoon.